Penalties Recovery Legislation Amendment Bill 2024 Serial 9 and table the explanatory statement. Madam Speaker, I move the bill be read a first time. Madam Speaker, I present a bill entitled the Fines and Penalties Recovery Legislation Amendment Bill 2024. On the 24th of October 2024, I introduced the Fines and Penalties Recovery Amendment Validation Bill 2024. That bill formed the first part of reform to amend the Fines and Penalties Recovery Act 2001. The purpose of that first bill is to retrospectively validate enforcement orders and subsequent enforcement action made under the Act in response to issues identified in the administration of the Act. Introducing that first bill in my explanatory speech to the Legislative Assembly, I noted the purpose of the Act and the role of the Fines Recovery Unit established under the Act in the recovery of monies payable to the Territory through the taking of enforcement action. I also noted that the Fines Recovery Unit had temporarily ceased undertaking enforcement action until issues with the administration of the Act could be fixed. The first bill seeks to validate retrospective enforcement action. This second bill, Madam Speaker, seeks to streamline processes going forward so that the Fines Recovery Unit can recommence its functions and continue to enforce and recover unpaid fines and penalties. This bill does this by amending how enforcement orders are made in Clause 10 of the bill, which repeals Sections 37 and 38 requiring an appropriate officer to apply for an enforcement order and replaces the provisions with a new Section 37 providing that the Fines Recovery Unit may make a penalty enforcement order. New Section 37(1) no longer requires an appropriate officer to apply for a penalty enforcement order or for the appropriate officer to certify criteria as met. New Section 34, as inserted by Clause 8 of the bill, is intended to operate to permit the use of a computer program to assist in the making of a penalty enforcement order under Section 37. Under the previous provision, an appropriate officer was formally required to certify criteria when making an application for a penalty enforcement order. Under the new provision, the criteria can be automatically identified in the IT system, which triggers the making of a penalty enforcement order. The criteria that will need to be met to allow a penalty enforcement order to be made are largely the same. That is, A, an infringement notice has been served on a person in relation to an alleged offence, and B, a courtesy letter has been served on the person following no payment within 28 days of the infringement notice being served. C, the due date specified in the courtesy notice has passed or a time to pay arrangement has not been complied with. D, the penalty under the infringement notice has not been paid. This includes additional costs associated with issuing the courtesy letter. E, the person is not elected to have the matter dealt with by court. F, no complaint has been filed in relation to the offence by police or other enforcement agency. And G, not more than 3 years has passed since the offence is alleged to have been committed. With the exception of G, this set of criteria has not changed, Madam Speaker. It is the process of making the penalty enforcement order that has changed. The criterion in G has changed to provide that a penalty enforcement order can be made up to 3 years from the date of the alleged offence. Currently, the period is either 12 months or, if the relevant period for when proceedings for prosecuting the offence must be commenced is longer than 12 months, then that longer period. This period varies depending on the offence and can be up to 3 years. However, the IT system does not recognise offences allowing for proceedings to commence more than 12 months after the commission of an offence. Therefore, the system does not allow a penalty enforcement order to be made outside of 12 months from when the offence occurred, even though proceedings for prosecuting the offence are still possible. It means that the Fines Recovery Unit is unable to enforce the unpaid infringement as a penalty enforcement order cannot be made, even if the Act permits it. This amendment ensures that longer periods are recognised and changes will also occur to the IT system so that penalty enforcement orders may be made up to 3 years from the date of an alleged offence. These changes are the primary amendments to this bill to streamline the process for making a penalty enforcement order, together with Clause 8, allowing for use of a computer program to facilitate the making of enforcement orders. Madam Speaker, this bill also makes amendments to Part 5, Division 7 of the Act relating to the enforcement action relevant to functions of the Registrar of Motor Vehicles under the Motor Vehicles Act 1949. These actions are some of the enforcement sanctions where a fine or penalty remain unpaid following the making of a fine enforcement order or a penalty enforcement order. These provisions of the Act allow the Fines Recovery Unit to suspend a driver's licence or vehicle registrations to encourage payment of the fine or penalty. As I indicated in the explanatory speech for the first tranche of amendments to the Act, these sanctions are commonly used across Australia, like bodies like the Fines Recovery Unit, to recover unpaid fines and penalties and are necessary to uphold a robust infringement and penalty regime. Clauses 15 to 20 make amendments to permit the Fines Recovery Unit to take enforcement action without having to ask the Registrar of Motor Vehicles to take steps to suspend a licence or vehicle registration. In addition to these amendments, the bill makes consequential amendments to the Motor Vehicles Act 1949 so that the enforcement action taken by the Fines Recovery Unit is recognised and upheld. Madam Speaker, further consequential amendments in this bill include no longer establishing the Fines Recovery Unit as a registry of the local court in Clause 4, no longer providing that the Director and Deputy Director are registers of the local court in Clause 5, removing the need for delegates to be a Justice of the Peace in Clause 6, and providing a general liability protection for acts taken in good faith in undertaking enforcement action under the Act. New Section 99A in Clause 24. Madam Speaker, the Fines Recovery Unit, being a registry of the local court, is a matter remnant of the old system where fines and penalties were enforced by the local court. The intent of the Act was to separate the enforcement and recovery of fines and penalties from the local court. While in practice this occurred, at law, the establishment of the Fines Recovery Unit as a registry of the local court retained the link with the local court in the administration of the Act. This amendment removes that link because it is not required. This bill forms the second tranche of amendments seeking to improve the enforcement processes implemented by the Fines Recovery Unit under the Act. This bill makes amendments to the Act that will allow the Fines Recovery Unit to recommence enforcement activities and will reduce the administrative burden on the Fines Recovery Unit in undertaking enforcement actions. It will commence immediately following the commencement of the first bill providing for validation. There is, Madam Speaker, significant urgency around both bills and a need to pass this legislation as soon as possible. Accordingly, I note that we will be seeking to have this second bill debated and passed on urgency along with the first bill in this sittings of the Legislative Assembly. I am pleased to commend this bill to honourable members and table a copy of the explanatory statement.
The question is that the bill be read a first time. Those of the opinion say aye. To the contrary, no.
Aye.
I think the ayes have it. The Clerk.
A bill for an Act to amend the Fines and Penalties Recovery Act 2001, the Fines and Penalties Recovery Regulations 2001 and the Motor Vehicles Act 1949.
That the bill be declared to be urgent.
The question is that the motion be agreed to. Those of the opinion say aye. To the contrary, no. I think the ayes have it.
Madam Speaker, I move that the second reading of the bill be made an order of the day for a later hour.
The question is that the second reading of the bill be made an order of the day for a later hour. Those of the opinion say aye. To the contrary, no.
Aye.
I think the ayes have it. The Clerk